Peace.
Welcome in,
Peace,
welcome
peace.
in.
Peace.
Greetings.
Yes, greetings to all of our friends in love. Come on in.
Hi, first time here.
All right. Yes. All right. Great day and welcome everyone to today's live. Today is the alleged with 23rd, 24th day of the month of March. In the year called 2026. And we're gathered here today on this wonderful Tuesday with all of our friends in law to have what has traditionally been our Newbie Tuesday, our Bible study. And I appreciate you guys being here with us today, as I always am, because it shows that we are committed to studying and showing ourselves approved. Okay. We do our best to keep things simple, especially on Tuesdays. And one of the ways that we do that is by reading comprehension. But however, we do also realize that their mental states, we'll say, that can cloud the mind from being able to comprehend things. Anybody know
Fact.
what I'm talking about?
Yeah,
Absolute fact.
One of the things that plagues our studies in law is our conditioning, our mental conditioning. We don't seem to appreciate that we have been brain dirtied from the time that we were put into school, separate from our parents, separate from
yeah.
our communities, teaching us about life and what to do and passing skills along and things like that. We don't appreciate that it's been since most of us were 3, 4, 5 years old that we have been brain dirty to perceive ourselves and our world a certain way. And then the fact that most of us don't begin studying the law until something else happened to us, some type of traumatic event. We got pulled over and perhaps beaten up. We got our children taken from us. We have our car taken from us. We've been dispossessed of our shelters. That's the trauma under which most of us begin studying the law after being indoctrinated and brain dirtied. Anybody know what I'm talking about?
Absolutely. The problem is even the police are brain dirty.
Yeah.
You can't
Whenever
talk to
we realize our own brainwashing, if you will, brain dirtying, I should say, and indoctrination, you realize that if it's happened to us, if it's happened to you, it's probably happening to even the ones we perceive to be our adversaries.
so true.
We're all created, both the victims and the perpetrators, in the same environment of brain dirtying, each taking on a what seems to be natural role in this setup. And we don't appreciate that phenomena. We've been brain dirtied and indoctrinated since 3, 4, 5 years old. And then the way that we get thrown into studying the law is after some traumatic, on some level, event. Because whose heart don't start beating fast as soon as they see those lights flashing behind them, even if it's not for you? Who can say that their heart don't skip a beat when they see the lights?
Yeah, it is definitely an unnerving experience.
Most of us do not start studying the law until there has been some type of damage or some type of threat of damage after years of brain dirtying and indoctrination. And then we think, bring it on. I'm ready to read the rules of construction. Bring it on. I am open minded and relaxed enough to absorb what they're saying with the rules of evidence. I'm going to master the rules of procedure.
Or
Anybody know what I'm talking about?
oh
Yeah.
yeah,
I'm going to go from being indoctrinated and brain dirtied about who I am, where I am, what I'm here to do, and then a traumatic experience, whether it's something as mild as getting a traffic ticket after your heart's beating out of your chest because you know that this street cop training be having these suckers just roll up and pop people,
word.
or something more traumatic like being displaced from your home or having your natural children taken away from you. That
Been there.
is that is not, who can agree that that's not an environment that cultivates reading comprehension,
Agreed.
absorption of information,
Yeah.
Agreed.
application of even the simplest remedies. And maybe we don't talk about that enough, especially on our Newbie Tuesdays. Getting arrested just because they don't know what, when we are in our private capacity, the codes don't apply. uh, that's one of the reasons that instead of saying it like that, we have to challenge the way in which they're applying the statutes. We have to make that shift because when we communicate it in that way, that it's not applicable in our private capacity, it's not considered court safe and it will not be, um, how should I say, supported, admitted to, relief granted upon those grounds. They're not doing that.
We'll say we got a friend-in-law that wanted to ask a question. They took a break from work to ask a question. It might, I'm just going to say, and I let them know it might not be a Newbie Tuesday question, but I wanted to encourage that when there's inspiration that's taking place, to at least get your question across the floor.
Yeah.
Because there may be someone that can respond, or we all can respond. And she put it in the chat. Um, it's Alessandra. She says her apologies. She's just at work, right? And she just wanted to put this question out there. No rush on answering it. She has a mortgage that she acquired in 2021 for her home in Florida, and she's in active foreclosure, and she is at the point of rescission. Would one recommend she pursue equitable or judicial rescission? Thank you. And let me just preface this because yesterday when I spoke with her, I was like to look at, the two of them to know which one is which and which one can be used at the stage that she's at. Um, I, I will say when we did the analysis in her Florida remedy, it 100 and 100,000 million% went with the judicial rescission. Um, because of the details of her situation. So she just wanted to get a third opinion on that, if not a fourth also. And I yield.
I like how you preface that with the facts being what yields the answer as opposed to just picking an answer.
Because the bot told me to. Let me stop. Let me stop.
Hey. Uh,
I know that's not funny, guys, but come on. Y'all know that's hilarious. Come on. That's funny.
It is. It's funny because I'm sure that people have either said it or thought it.
Yeah,
Okay. Um, so it's about looking at your individual situation, how to decide which to choose because they all have their pros and cons, and it's all going to depend on where you are with your situation.
word.
So if you have thoroughly researched the benefits at the stage you're in of both of them or either of them, then whatever decision you come to is going to most likely be the right decision.
Absolutely correct.
Does anybody else have anything they want to share on that?
What we could do if you want, I could screen share what was said in terms of what it was, what the response was, to kind of just briefly show what the outcome was, if you want. But yeah, I told her, I was like, you never know, the team going to say something, speak up. Maybe of course, Malika and Queen, at least for starters, could let it be known. But to preface it further, I think it would be equitable, right, to share the screen so that you could see what it was, right? Is Alessandra actually still with us? That's what I want to know. Let's see. Yeah, she is. All right, cool. So let me, if I may, bring it up real quick. And of course, Mammy wants to add in too, right? Um, so where did I say what I said? I think right here, right? Um, and let me see if I could, so you could see my line of questioning, right? As far as the prompt's concerned. Okay, I got it. Let me share screen here. Share screen. And forgive us, guys. I know this is a more of a Thursday level question, but I know that we've been allowing some Thursday, Friday preview material come across, right? The floors. So what I had prompted in brief conversation yesterday. Are we waiting on something, Lotus? Okay. Um, what is equitable rescission in Florida? What is judicial rescission in Florida? How are they alike? How are they different? Which one can be used favorable for a 5-year mortgage contract that the borrower is aware is in breach? Okay. So it gave the answer to number one, it gave the answer to number two, it gave how they're alike, it gave how they differ, right? Also used, of course, construction principles, which is more favorable was where we, got to it. And for that, it says, which is more favorable for a 5-year mortgage contract in breach, right? I guess let me turn this thing this way so you guys can get more of a full screen, right? So short answer, judicial rescission is the superior and safer vehicle. And this is not for every time, everyone, everywhere. You see that what was asked was specific. All righty. And I know this is rare that, we share how we do that. But and I'm sure Malika, as well as I've seen Queen, when it comes to you guys booking a session with us, there are at times we'll give prompt coaching when it is absolutely needed. We don't want you guys to not use your own minds and think. Okay, so that's the only reason I shared that particular prompt, right? And this is in a Florida remedy. Okay, so there's already things already ready already. Um, why strategically and doctrinally a mortgage contract implicates property rights. You are not dealing with a simple bilateral contract. You are dealing with recorded instruments, security interests, potential third party reliance. A unilateral equitable rescission will not clear title or extinguish recorded encumbrances. Necessity of a binding decree under Florida law. Only a court judgment carries enforceable presumptive validity. Maybe, but we'll just continue to see why. Without it, the lender or assignee can ignore the rescission. The foreclosure can proceed as if no rescission occurred. Breach alone is not enough, must be material and structured. So, again, it's referring back to what I prompted. Courts scrutinize whether breach is material, whether borrower can tender restoration, whether equities favor rescission over damages. Offensive versus defensive posture, equitable rescission alone would be weak defensive notice. Judicial rescission, affirmative claim that attacks enforceability, forces lender to prove standing, compliance, and legitimacy. Uh, Tactical overlay for our friend-in-law's framing for an unrepresented but competent, right, friend-in-law. Emphasize legislative scope and applicability. Argue the borrower is not within the class intended to be burdened. I don't know about that one, but I know why I reach for that. Absent strict compliance, so that's still suitable, right? Of course, as far as the language is concerned, I don't want people to get too much into. Well, I'm not the person that. That's not what we're really looking into. What did the legislature provide? You know what I'm saying? That's really what we're looking at. We're looking at the scope and applicability in terms of that. Challenge whether the mortgage instrument was lawfully formed, was properly assigned. That's what I would be looking at, right? Which is the properly assigned. Falls within statutory enforcement frameworks. I'd like that too, right? So, and then it gives a legal posture, right? Which I'm not going to really go into too much or whatever, but the bottom line, it gave, for this particular, this is not, oh, well, equitable rescission is only theoretical, it's theoretically right, but weak standing alone. That's for this particular situation. It might be different for whatever stage you're at. Okay. Just wanted to make sure we're clear on that. But I only did that because I know that Alessandra will be working. However, the floor is open, right? I'm sure.
My question is whether a judicial decision can be used as a counterclaim in Florida.
I
That might
think
not be so very newbie, but is absolutely a question that if it can be used as a counterclaim.
think the
In,
judicial rescission could be. I think I saw that somewhere.
so I would suggest that not just Alessandra, but anybody else look up and see if you decide to do judicial rescission, if it can be used as a counterclaim in a judicial foreclosure.
Yeah, that's
And I
homework.
yield.
Yeah, indeed. That was great, sis. No, that's not in what I just shared. That's actually in something else that I'm cooking up and I will be presenting Wednesday in Amicus. But that did kind of come up, but not specifically that way. But I think it is possible. But that is great homework to see, if that can be used as a counterclaim. So that is genius. I yield. Anyone else? Well, if not, Linnea has her hand up.
Yes, I do. I got a newbie question. Can you hear me okay?
Uh, okay. Once you said okay, you sound like you got closer to the mic.
Okay. Okay, good. So I have a newbie question from a loved one. She asked me this question and I wanted to like fire hose her with information, but I had to just stop myself and take a breath because she's mentally not in a space where she can handle a ton of information. So I will ask this newbie question and hopefully you guys can just give me kind of a simple answer to start her with. and then I can walk her forward from there. Okay. So
Mm-hmm.
her question is, she's older. She would like to protect things like her home and I guess her money in her bank account, perhaps, from a child that she wants to make sure at her passing does not try to, I guess, fight for her home against the person that she gives it to. So she has been reading a book about trust and she wants to know, should she put the house in a trust? Why should she not do this? I said, no, don't do that. But she said, but why? And I said, so that is my newbie question.
I
Why
have
should she not put her house in a trust?
I have a clarifying question because a little more information came across the floor, if I may, before we get to that
Sure,
answer.
sure.
Is and she wants to prevent a child from receiving the house, one of her own loved ones, right?
Right, and an estranged loved one.
Okay.
Be- because the house is in the possession of her other child. So she knows that this house is going to go to the other child, but she just wants to make sure that this other, her other child, her son, isn't going to pop up out of nowhere. I don't really even think it's an issue realistically, but
Gotcha.
she wants to feel protected and she thinks that this trust is going to protect her home.
Okay. I'll eliminate the family feud of it all out of my mind as best as I can because I don't know the details because it could be other things, of course. It's sad, but to be constructive in the answer, um, did she write a will? That's my question.
Um, well, that was the what I suggested to her. I said, well, you need to just write out everything that you wish to be done, and then we'll carry it forward from there. Um, I said that if your house is you've given it to whoever you need to give it to, you're gonna give that person the keys. They are local, whatever, they have access to the house. I said, why would you need to her first thing she said is, I want the government out of my business and I don't want this son to use the government to take the house. And so I said, well, if you don't want them involved with something, why would it make sense to register that something with them? And her reasoning was, well, maybe they'll protect it. Ah,
Interesting. Interesting. I mean, for me, it's the will. Anybody else?
okay, that's kind of where I was at as well. And it's like I didn't think it made sense to sit there and try to walk her through the language in the trust
That's
statutes
why
in Florida.
I like to have people walk me through their logical or illogical thinking and ask them how they see it working and based on what, instead of, me trying to pour something into them. Because sometimes it's not until people say things like, I'm going to start a trust, not for a reason a regular trust is supposed to be started for, but for some manufactured reason that they heard on the internet, which is unlikely to assist them in this actual situation that they have. But they don't know that because they haven't started reasoning on their own yet. So that's a perfect example of what I was saying in the beginning of the call with people's thinking mindset coming from being indoctrinated and brainwashed. And then a lot of us took being guru abused with information that sounds like some type of a universal fix.
Yeah,
Yes,
I get it.
that's how it
I was about to ask Linnea, like, wow, you met my mom? Let me stop. I'm just serious. Go ahead, I'm listening.
is that what's going on with mom?
No, I
That's a
mean,
lot of
I'm
mamas.
her only child, but that sounds like her personality. But go ahead, I yield.
So I just wanted to say that to everybody. I hope you guys understand what I'm saying. I hope you would find it helpful had if you are truly a beginner as well, of why it's best to question your own belief and why you buy into whatever this process is might work, so that when things are done, it is you who's actually taking responsibility of that choice and not deflecting or deferring it to somebody else that told you something. You have to have your own logic and reason. And I know it makes people feel uncomfortable when sometimes I'm the one to ask those questions. They might feel like I'm badgering them or whatever, but I'm trying to empower people. There's a lot of people who will show that they do not have what it takes to live as free as they might tell others they wish to,
Word.
because it requires a level of responsibility, guys. The freer you wish to live is the more responsibility you have to take. It's the for your what you think, what you say, what you do, why you think, say, and do those things. And a lot of us don't really know why we think, say, and do things. And that's one of the reasons also that we're easily misled. We start off answering questions with someone told me or I heard, when questioned about their reasoning, about their thinking, about things that are supposed to be in the law that we can all point to and recognize. Principles. Okay. Any other Newbie Tuesday questions, guys? Gratitude for sharing, Linnea. Appreciate that.
Yeah, indeed. Gratitude.
Could I
Sure, if
ask
I
a
could
question?
share. Oh, sorry. Go
Oh,
ahead. Go
no,
ahead,
well,
bud.
go ahead.
Can you guys hear me okay? All right. So
Word.
I'm just gonna share a small success, which later I realized
What? What?
was a big success.
All success is big success over here. I
Yeah.
don't care what y'all be talking about.
Word.
So just to recap, I think it was about a year ago, I got a text message from a debt collector telling me he was going to foreclose on my house because of a bond. Well, the bond was
The
satisfied.
$4,500 or something like that. This was the guy that
Yeah,
texted you all of that junk,
yeah.
laughing and stuff like that.
Right, scaring the shit out of me. And so the power of the notice of claim, and so I sent that off, the notice of claim and claim of damages, and never heard from him again. And recently, I just looked up on the county recorder to see the lien that was on my house, that was still on my house, and it wasn't there. And so I called the county recorder and I said, "Hey, um, where's the lien that was on the house?" And she goes, "Well, there's no lien recorded." I said, "Well, it's there. It was there, wasn't it?" And she goes, "No." I go, "Well, did someone delete it?" She goes, "That's impossible. That doesn't happen. That would never happen." And she said that. I'm like, okay. So I actually was going through my paperwork just now and I found the lien. After that, I called the company, the bond company, and they said, yeah, that's released, that's gone. And incidentally, I did get communications because I did send the notice of claim to the company, also sent a copy to the Attorney General. The Attorney General replied back, we're not going to do anything now, but we're going to save this file in our records. And if something comes up, we're going to keep it under for investigation. So, I put all two and two together. And after I called the bond company, they said that the lien has been released.
Mhm.
And so, after putting all the dots together, they removed something that wasn't supposed to be removed from the county records. And so that's the power of the notice of claim and claim of damages.
Wow, that's amazing, Don. Congratulations. So you have proof
I
that
have
it was
proof.
on there,
I have proof.
and
Yes, I
then
have.
proof that
It's
it was
gone.
removed from there.
It's not there. And in fact, I looked it up, and I called the county recorder, and she's like, and looked and looked. I said, nope, it's not there.
And then they tell you that it's an impossibility for it to have been removed.
And I recorded the conversation. Yeah, so I'll have to dig it up, but I'll might play it or send a snippet of that later. You can play it, but yeah, yep.
So why do they think it's an impossibility to have it removed?
I didn't get into that, but that's what she was claiming, that anything that's filed on the county level with the county recorder does not get removed. It's permanent.
So what do they typically do? What does the county recorder do when a release is filed? They just also record the release.
Yes,
So everything has to stay. So they would call they would report the alleged lien and then report the alleged cancellation,
correct.
but not just a deletion.
Not a deletion,
So
correct.
now you have potential evidence of tampering with a government record.
I do.
Oh my God. I think that might be when you bust out the consumer protection on
Ooh.
their ass. What y'all guys think?
That's funny. That's what the off-duty alibi post is today on YouTube.
How are you doing this every Tuesday?
I have no idea how you're mentioning something like I'm literally. What'd you say? You sound muffled.
Yeah, you sound muffled. You got to do something with your mic.
Maybe they're not talking to us. Okay, you guys got to it before I got to it. Okay, cool. I mean, Eldon, how did you come around to getting to this point where these people are deleting things or getting rid of things?
I'll send you the information if you guys want to verify it yourselves. But I do have the lien in my hands that was recorded with the county recorder. Found that today, doing paperwork clean. And like I said, I called the county recorder, recorded that conversation. Records do not get deleted, and even went through the process of what you just said, Malika, as far as recording the lien, then recording the lien release. So, yeah.
Was this
I
from
mean,
documentation recently that you recently put together, or this was?
He did it a year ago, right?
yes.
You
So,
guys, some of you guys at least should remember that. That was crazy.
Yeah,
He
yeah.
was showing us the text message of the guy laughing, saying, "I do this all the time. You're gonna pay." He
yeah,
posted the screenshots of the threats on lawful living on the
Yeah.
website.
I think that is refreshing my memory. First of all, let me say this: woohoo! Yay! Way to go! Yay! Okay.
Yes.
you.
And I do think you do now have some grounds of some sort. pertaining to some type of consumer protection claim. So you know, some consumer protection
Check
violation.
this out too. The Arizona Department of Insurance, they wrote me a letter because I sent them a copy of the claim, and they sent me back. I think it's through email communications, and I'll put that together as well. But they said that I am responsible for the debt. They said it, and they said,
That's fine. Can they
yeah,
prove
they
that
said
these people
a
can
few different
enforce?
things. Yes,
I'm telling you, that's that shit they don't like. They want
but
us to say things like, "Oh, this doesn't apply to me," which we all know in our heart of hearts the shit don't apply. But the way to communicate it is to make them prove their side, and that's what they hate. Because most of them, I'll say most only because I don't want to be like overly confident, but we've actually not met any of them that is able to prove anything. And I hope you guys that are in the advanced class, even though you might be here today, remember that attorney Shannon that was asked if her client was the holder of the
Mm-hmm.
original promise note, and they confessed that they have to now go their client that where the law requires that they would have known the answer at least. It doesn't matter if the answer is yes, they are, or no, they're not. The law requires that they should have known that because when the attorneys have a responsibility, a duty for a pre-filing investigation into the law and the facts of the case
Word.
before it's even filed. So if your client is the holder or not, or if they're just an assignee, is something that would have been revealed in the beginning prior to the filing of any case. Y'all see what I'm saying? If they
Excelente.
would have done their pre-filing investigation into the law and the facts as the law itself requires.
Excelente. Excelente.
It be getting spicy when you know the beginning of the nexus, right? And the genesis
Correct.
of things.
Yes.
When an attorney that's already filed a case is saying with their mouth that they have to go now inquire into a material fact like does your client own the or hold the original note, or are they mainly an assignee? They want to get defensive. Oh, well, it's not required that they're the holder. We're not saying nothing about what's required. If they're the holder, you don't even know if they're the holder.
Correct.
Because if they're not a holder, they could be an assignee or they could be none of the above. But regardless, the attorney's supposed to already know the answer, not confess at the time after the fact. I now have to look into it. Now she's completely silent.
Are you talking about holder in due course, Malika? Is that a more definitive what you're
You
asking?
can call it a holder in due course or
Let
just a holder, but if in order to be the person entitled to enforce, you either have to be a holder, it don't matter which one you want to call it, but somebody who's in possession of the note, or somebody who is an assignee of the one in possession of the note.
in the spirit of legal writing in plain English, you know what I mean? And to add to Malika's wisdom, because you totally answered that and nailed it. It is, and this is from, if I'm not mistaken, Malika, from your recent research. Um, at the time
Look at your
that
mouth.
these people are asserting their claim, at the time they're asserting it, who was the actual holder of the note? That's another way of saying that, the holder in due course. That's fine, but let's if we can do some type of, in the spirit of legal writing in plain English, right? That Brian A. Garner type vibe. Who at the time when you guys are saying we're about to enforce this right that we know doesn't exist, uh, when you guys were doing that, who was the actual holder of that note, and when did they assign you, and provide us a date stamped,
Yes.
documentation showing both of those.
That's the
That's really
questions
what we're
they
saying.
don't want to answer because we've brought it down to who, like the question is who was the holder at the day the case was filed? Who
Correct.
was the holder at the date that the substitute trustee notice was filed onto the county or the notice of default was who was the holder? Because again, their duty before the institution of a case is to look into the law and the facts. And that's not a duty that we created for them. It is what's required by their rules of professional conduct and the rules of procedure and the
Word.
rules of evidence. I like that, Tice. Officious intermeddling. Somebody else, I think, Trading Brigade. All right. Or was it Keith that brought that officious intermeddling to the
Keith, it was
forefront
Keith, it was Keith,
years ago? Yeah.
was Keith, was Keith.
Okay, gratitude. We calling them out.
Word.
Yes. The difference between holder. Yeah. We don't care if they're the holder or the assignee, but they have to be one or the other and be able to prove it. Do you guys understand? And this is for credit cards and car notes and stuff like that as well.
So I found the first letter from the Attorney General, and it says, "Our office represents the state of Arizona and is prohibited by law from representing individual consumers. The Attorney General's office, however, does bring cases,
Jesus Christ.
against businesses that violate Arizona consumer protection statutes.
Uh-huh.
That is why the information in your complaint is so valuable.
Yes.
Assist this office in identifying and tracking a possible pattern of conduct that could warrant future action. If that were to occur, your complaint is on file and will be reviewed again."
So, okay, I'm sorry. Go ahead, though. No, I'm excited.
Yeah.
Forgive me.
There was just after that, they were giving me some legal advice. If you decide to hire an attorney and pursue this case on your own, here's some resources for you.
So, to
And you may
me,
also consider filing an action on your own through your local court system. Thank you for taking the time to file your complaint. Sincerely,
I
Consumer
hope they got
Information
a copy. I
Complaints.
hope the company got a copy of that letter.
That's what happened.
I made you a folder, right? Oh, Don.
Possible.
Right, where the session recording file was, where it was made, right?
Yeah, I can look it up.
Can you upload what you have there?
Certainly.
I'll make a uploads from I'll make an uploads folder for you right now because that's sweet. And then I'll check your Arizona remedy to make sure you have the equivalent of what I'm working on right now, FCRA, FDCPA, and UDAP, because that's what they told you in that letter. When they talked about the conduct, they're talking about the unfair, deceptive acts and abusive practices. We just would have to find what is the Arizona analog to the same.
The date of this letter, by the way, is April 15th, 2025.
Inter and you're just getting it?
No, he had everything from years ago.
Okay. That is interesting. Absolutely interesting. That is excellent. Look at that. Even before we use these large language models, ass was getting kicked. Look at that.
Exactly. Come on. Good boy, man.
Exactly. Now we got power tools. Don't be like, you can't build houses with a power drill now. Like, stop it. That's what those attorneys are crying about now, that we're using power tools.
Look, they've been using their obfuscation of the law, their intimidation because they have a degree. Anybody know what I'm talking about?
Yes.
I do.
They don't know procedure, but they know we don't know procedure. So we don't know when to tell that they don't know procedure. That's what they were using, our ignorance. So that's using psychology against us, right?
Word.
So, and the attorneys are the deep state. For those who don't know, if you're actually new here, the attorneys are the deep state themselves. This is
Yeah.
why the president yesterday could say, yeah, we're going to cease fire, no more this and that. And then hours later, somebody drops a bomb because the president don't run shit like how people think they do.
He's a
Well,
figurehead.
he's manipulating the markets when he's talking, but other than that,
I don't care what y'all say. The president does not run anything.
Yeah, he's a figurehead.
Okay. And that's why they can say ceasefire on Monday and things still happen hours later. You either get that or you don't get that. Ain't no 3D chess, 5D chess going on around here.
The billionaires are in control. The president is just their bitch.
Well, I don't know. He seems like part of the club being a billionaire himself.
Well, I just meant
At least he's
the
not like
position.
some of the other Congress people that get rich after they get to Congress.
Right. I just mean the position of president. It's definitely not the top of the totem pole, that's for sure.
Absolutely. Absolutely.
Word.
All right. And that's why it's so important that we get our houses in order, guys. I know that homesteading on any scale is not on most people's radar. When we started learning how to grow food, we were still living in a McMansion home that had an HOA, okay, and a regular fake ass mortgage like everybody else here. Oh, um, and we didn't imagine that eventually we would need to take that, I don't know if you want to say inspiration into the mountains where we are now in Washington. Hold on, guys.
I still think, telepathy is amazing, and we
But
definitely have it in Amicus.
I will encourage each and every one of you, regardless of where you are, to start homesteading principles. Okay. Like I said, we started learning how to cook certain things and learning how to process things even if we didn't cook them, learning how to make your own salad dressings, learning how to make your own condiments. I was ready to start tearing up grass and seeing if I could grow some mustard. Okay. I started learning how to grow cotton. I remember thinking to myself, I'm never going to the store for underwear again. I'm going to grow my own cotton and make my own underwear. All right. I'm going to take over every aspect of my life. When I became inspired to take responsibility for my mind and my life, I I said and aspired to do some crazy things, some of which I'm still trying to implement right now. But I'm just going to encourage you guys, because if you're not sensitive to what's going on in the political theater, okay, and how it might affect your family life, and of course your direct life, your neighbors, okay, your siblings, your parents, if they're still with you, it will affect your life. And if you're not already thinking about how you can create and contribute to your local community, you are behind. Anybody know what I'm talking about?
yep, just picked up some manure
Absolutely.
from my neighbor.
That's what I'm talking about. That's one of the best ways. That's one of the first things we did when we wanted to give our kids a tent experience. We'd never been camping ourselves as adults, so we went and got a tent, and we went and got some sleeping bags, and we had a camp out in the backyard just to see how it would be. And we left the tent up so long that it killed the grass underneath. And so we decided to um, put some cardboard down on top of the grass that was already dead and throw our compost on top of it, of our kitchen scraps and fruit scraps especially. And guess what? Without planting anything intentionally, we got eggplant, we got peppers, we got unknown tomatoes, we got cantaloupe. It was like Christmas, but better because food. Okay. And we didn't plant anything. We were so spoiled. I was like, you can just throw your freaking compost out here and stuff will just grow. This is like, wow.
Yep.
Because I was making a plan. I was like, I'm going to put this over here and that over there. God was like, let me show you. Let me show you. Let me show you what I done did. Okay.
It's like
So,
nature almost wants us to live.
okay. Okay.
Real.
When I told my mom, and I just knew, just for those who think you need help, you need somebody else. I thought I was gonna have my mom help me because she always had plants in the house, right? She's always, even when we lived in Florida, Florida shouldn't even count, trees just grow wild, especially in the older neighborhoods, which they're trying to get rid of. But my mom never actually grew food. So when I thought my mom was gonna help me, and I was like, all right, mom, let's get it, let's do it. She was like, oh, I don't know anything about that. We moved to America so we didn't have to do that. And I was like, what is happening right now? Okay, whatever. And I just did it myself. And now my mom asked me for gardening advice. And I was able to set up a small garden in the back of our sister's house that was only 10 minutes away when we lived in Texas. And since we've moved from Texas, we've learned a lot. And it's one of the reasons that we moved from Texas so that we can mhm, so that we can grow more food and share it with more people and inspire more people to do so. And not just because it's fun and did I mention there's food? Okay. But it's a political statement as well, because the more somebody else controls your food is the more they control you. And I am sick and tired of people being sick and saying they're sick and tired of what's going on in the system, but they don't have any alternative. They don't have any desire. And I'll tell the story forever. I had a friend that went, because I was always encouraging people on Facebook and everywhere to grow food, regardless of how little. Okay, grow herbs on your freaking windowsill. Okay, I don't want to hear no excuses. Grow determinate tomato varieties on your balcony, even if it just gives you a couple of salads in the spring and summer. Just do something to empower yourself and go in a direction where you can create community. Imagine if communities made even just a couple of raised beds in their front garden of something that somebody else in the community can do the same, and you can share that. Put these grocery stores out of business. You guys not tired of hearing that they got a recall over this? A recall. They had recalls over lettuce. When are you gonna draw the line? Where you guys gonna draw the line? They had a recall over lettuce, guys. Nothing. What's safe at the grocery store? Somebody tell me.
Precious little.
The Federal Reserve notes in the safe. Okay.
Right. The water's not even safe. We got a water distiller.
Same here.
It's just a distiller. So technically, y'all know what I'm talking about. We can distill anything.
Hey, yo.
The floor at the grocery store. That's right, Carmen. Everything. Anything. Anything can be distilled. Yes, Lisa says I'm growing watermelon, cantaloupe, cucumber, squash. Let's get it. I got 6 different types of watermelon we're gonna grow this year. I'm very excited. Anybody else? There was one time I didn't even like watermelon. I prefer
Wow.
honeydew and cantaloupe. I'm like, watermelon. I grow stuff I don't even eat. I grow okra. I don't even eat it, but I give it to my family because they like it. I'm growing one that's yellow on the inside, and then I'm growing another one that's yellow on the outside. We have to get things. We have to get this law stuff handled, guys. We got to get these attorneys. Teacher, open both those windows. Open both those windows. We got to get these attorneys on the run. We have to use law, equity, including the consumer protections when needed. And most importantly, we have to get our mind right so that we can recognize the applicability. These things are simple, but only when our mind is not clouded with fear and bitch assness. Anybody know what I'm talking about? Some of us might have to take it to the appellate court. Some of us might have to take it to the Supreme Court. But if you know the rules and the law and God is on our side.
Amen.
I'm talking about the big G, not the little G's. Okay. The county court set up a court hearing for April 9th for the motion to strike. It's going to be on Zoom. All right, Lisa. All right. All right. Who else got their hands up, guys? Let's go.
May I ask an issue? Can you hear me?
Yeah, we can hear you, Ambassador Michael.
Oh, okay, thank you. I'm new here. Recently had a fender bender with a friend, actually, in a flea market just a couple Saturdays ago. The police came. I don't drive with a driver's license. My car, my vehicle, my automobile is registered in Washington State, part of the church motor pool. So it's not my motor vehicle, although I manage the motor vehicle. I keep saying motor vehicle, the automobile. They gave me a ticket for having no insurance and presuming that my car should be licensed in North Carolina, though it's not licensed in North Carolina. It's, as I said, licensed in Washington. Since then, I found a document in my folder called Certification of Self-Insurance, which I gave to the police chief yesterday when I met with him. Actually, no, I didn't. I talked to him and he blew me off, just like his officers did. Doesn't even know what a driver in law is. And I gave him this certificate of self-insurance after the meeting. I dropped it off at his office so he could see it. I've got the abatement done. On the citation, of course, it doesn't have a driver's license on it, doesn't have a state on it. It just says source other. It's called a citation, no social security number. And again, the only thing he wrote me up for was having no state insurance on my vehicle, on my automobile. The abatement's done. I'm going to submit it probably on Thursday this week. But I'm wondering what is the next thing. A friend who also comes to your class, Veronica, suggested that a tort would be the next step. Is that what you think it should be done? Oh, by the way, I also ordered yesterday your private license plates.
All right, thanks for sharing, Michael. One of the things that we have to realize as newbies is whoever is the accuser, whether it's your neighbor or the state, has to prove every single one of their elements. And our knee-jerk reaction is typically to try to prove something to them. Anybody know what I'm talking about?
We try to
Yes.
defend ourselves.
Yes, we think we automatically have to defend ourselves. So we start pulling up stuff and we start trying to show them stuff and we start trying to open their eyes and we just start. Is that what Michael is doing? Or is that what he just expressed?
They wrote me for.
Yes.
They wrote
Does
me for
anybody
2
else see? It doesn't, you gotta listen, Michael.
Yeah, what
can't-
Malika's saying is whatever claims they're bringing poke holes in their claim by showing that they're not meeting the elements of their claim. That's what she's saying.
Yeah.
For example, if they're saying that they're fining you for not having insurance, they're supposed to bring the facts and the law that show you are supposed to have insurance. Not just a law that talks about it generally, but that is one of the elements they have to prove. So the charge for not having insurance has elements, okay? And they have to prove every single one of those elements. Not us printing out things and going into our files and finding things and then trying to show it to them.
Mm-hmm.
The next thing is that tort claims are typically step one for us over here, not step next or something else further down the line. If I get a ticket today, I would try to get the tort claim out today. If not tomorrow, maybe the next day after that, if I'm not familiar with something.
So
With
don't
only
do.
due respect, hold on, Michael, one moment. With only due respect, Malika, since the mic issue kept happening, I'm the one that put them in the waiting room. Respectfully. I yield, Michael. Continue.
I don't know what I said. Oh, I asked, should I should not do the abatement? I should do the tort first? I feel like that's the information that they need because, I
You can
didn't
use the facts that they did not meet their burden of proof for the abatement.
Okay, I include that in my memorandum.
If you know how to do a memorandum, if a memorandum is allowed in that venue and on that level, the main thing is to get the principles and to make sure that you know where the burden of proof belongs and you not making claims on that you will then have to prove.
Right. Okay.
Hey, Malika, his car was towed also. I think you forgot to mention that, Michael.
Net.
And that's kind of messed him up because he's been without a car for over a week now.
When it comes to results, right, in this thing, I'm not saying that we haven't had friends in law have some results that may appear to be microwave, like they were quick. However, since this is a spiritual walk that we're walking, right, and a lifestyle choice that we're experiencing here, we have to allow ourselves to really wrap our minds around if this was a boxing match and we're pugilists, so to speak, if this was a pugilistic exhibition, we have to expect to go 12 rounds, not just the first 30 seconds of the first round, like a Mike Tyson fight back in the early 90s. So I said all of that to say is we have to prepare our minds in a way to be able to expose these people procedurally. And what Malika was saying earlier was to poke holes in their element in their claim by showing the procedural defect that they're not meeting the elements. Yes, it is a nuisance to lose your conveyance the way you've lost it. I might have missed it earlier, but what initiated the stop, Michael? If I may ask again, forgive me for not listening attentively.
An accident.
Okay. And when it came to this accident, right? Someone injured you.
No, I was pulling my trailer into the flea market, and my trailer fender caught another car's quarter panel.
Okay.
It's already paid for. I paid for it the next day, so it's already taken care of.
Okay. So you made these people whole, yet there is something extra happening with the policy enforcement.
The state wants their cut. The
Once
state
they
wants their cut. They don't
Mhm.
care that you took care of the other party. They don't want to mind their business.
That's right. They don't want to mind their business.
and the state got involved because policy enforcement was called and a ticket was written.
They just showed up. That's what they do sometimes. They just
No,
be showing the fuck up.
they were called. The man who I hit called them.
Okay, so you got a mail Karen, got you. So
Mhm.
so yeah, I know, right? They call them Kevins
Did
sometimes too.
that.
No offense, Kevin. So okay,
Oh,
so now that you have that, so now that you have that as the issue, what needs to happen is what Malika is suggesting. And if I'm wrong, if I'm loud and wrong, I'm open for correction. But it's to poke holes in their claim by showing the procedural defect of them not meeting the elements of whatever their claim is.
So they're claiming that my car is is licensed in North Carolina or should be licensed in North Carolina, when in fact it's being held as a ministry car in Washington State. There is
You
no.
keep trying to prove that when that's irrelevant to their charges. If they are claiming that it has to be licensed and or registered, they have to prove every element, not you volunteering information about Washington or Virginia or licensing or any of that.
But the fact is, they've got my car. I I think maybe I can get the car out now that I have the certificate of self-insurance. I may be able to get the car out, but I want them to pay for the fees. I want them to pay for the towing. I shouldn't be the one that pays for that. That was their bad.
You're probably going to have to pay for it yourself and again collect on the tort claim because
Yes,
that's damages having to pay.
that's what I'm expecting. But I think I might be able to get it released now that I did remember the certification of self-insurance.
Tort, 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 tort.
Yeah, that's what Veronica was saying. But I have no idea how to do a tort at this point. And I know nothing about torts. I do know that it needs to go to the city's.
The good news is that online and in legal libraries, they have the state Tort Claims Act and the municipal level Tort Claims Act. They tell you exactly how. They even usually tell you where, who you have to serve, all of that. It's not hidden, but most people are not even aware that tort claims exist, what they are, when to use them. And for those who are new, we have a class. Our affiliates can put the link to the tort class, Torts for All.
Yes, that
Okay.
class would be very useful if you feel like you're not quite sure how to do a tort or what a tort is.
Yes.
but I'd be looking at a municipal tort.
All of them.
Definitely all of them, because depending on who you're interacting with, that's going to be the level of tort claim that you do. So, for example, our son got a ticket from a city officer, and so that was the level of tort claim. But then his brother got a ticket from a state trooper, and so the tort claim was sent to a different location. Of course, the principle is the same, but based on the entity, that might be different. And again, our affiliates can post the link to the Torch for All class here in the comments.
Okay. So it was a policy officer, and it went to a county court, it sounds like.
That's fine. But I think would be important for you is to, again, analyze whatever's been docketed, analyze what's on that docket, or get in contact with what sounds like some county district attorney. See what they said, see what was said, see what was put on the record, and prepare to poke holes in that so that you can have that one thing taken care of. The tort claim is technically separate from that, even though it is inspired by the policy enforcers being called and asserting their authority where it wasn't necessarily needed. So
you're not expecting that I get an attorney, certainly.
Say that again.
I said, you're not suggesting that I get an attorney.
I'll say this one more time. You check the docket where they are bringing, the state's bringing a claim, correct? And you already began doing your best to fend them off, yes or no?
I don't know if I have a docket. I have a citation. They called it a citation.
Okay, and this is for North Carolina, yes or no?
Yes, sir.
Have you at any point in time checked or did a judiciary case search on that particular citation?
When it's just traffic tickets, it doesn't usually go like that. As I mentioned, a lot of times we'll talk to the clerk will say nobody's assigned to the case because they don't do anything on your case until you respond. So since traffic are citations and they're not typically civil cases, or handled as typical criminal cases, again, I'm going to recommend the class and the basic information that we gave him because we don't want to overwhelm him.
Okay.
When it's traffic citations, they don't usually require any type of auditing. Okay, you got the citation in your hand, so you refer to the Tort Claim Act, and of course, even if you wish to do an abatement or some type of notice to the court, it would be like in California, for example, you can do it by mail. They call it something contesting by mail, for example, and it can be handled that simply.
Yeah, forgive me. Just thinking about that municipal docket, but go ahead, I yield.
You said something about being canceled by mail. Was that the citation or was that submitting the tort by mail?
If you're not in California, it doesn't even matter. It was just an example that traffic citations are handled more simply than traditional criminal or civil dockets. So typically on the docket is just the citation, and a lot of times there's not even a judge or a prosecutor assigned until there's some type of response.
Okay.
All right, thanks for sharing.
Yeah, I'll check out the tort class.
Awesome. Who do we have up next?
I think Asa, if I'm not mistaken. Yes, it's Ozzy.
Hello, thank you.
Peace.
Greetings and blessings, all. I have a newbie question, but I want to first say that to what Malika was talking about, creating our own food supply, that I have a tower garden in my house that I've been growing vegetables in, and that as soon as I win my foreclosure case, I plan to buy a large piece of land and create the Unite and Thrive Eco Village. Just wanted to input that into the conversation that Malika had earlier.
Woo, woo, woo!
Yes.
Indeed.
That's a really good change in attitude. I like the very positive that approach that you're taking there. You're gonna win this case,
Oh
right?
yeah, I'm definitely winning it. I have no doubt.
That's a
Yeah.
change. That's good to hear.
Yeah. No, well, I haven't been talking about this case that much. So anyway, yeah, Rosklat going to win on this. Anyway, my question, I also want to say I agree with the with Hassan said about the intuitive alignment, because my question was about insurance. My newbie question was about insurance, because I purchased recently a used car from somebody and they didn't even want to release it to me until I got insurance. And I was like, what? It's not even according to their legal laws that, their statutes and codes that I have to do that. But anyway, I was just curious. And when this gentleman was speaking about self-insurance, I looked it up quickly and it said a certificate of self-insurance is an official document typically issued by a state agency. And then it requires demonstrating significant financial stability, such as high net worth or minimum number of registered vehicles. And in New York, it's like a business, and they have to have 25 or more vehicles. So I was just curious, how do people deal with insurance when you don't want to have insurance and you want to do Matthew 18, 13 through 15, I think it is, about if
Number
there's a
one is
problem?
typically not calling the policy officers due to the fact that it creates a situation that we just went over a few minutes ago.
Yeah, but like he had the situation, the other person called, whether he liked it or not, they did it.
Right. But that's what I'm saying. Step number one is making sure that that doesn't happen, because I'm speaking from firsthand my experience of causing an accident several years ago, and neither of one of us called the policy officers, and I still made the other person whole. I just also didn't have to deal with a ticket for not having insurance.
Right, right.
May I say that my certificate of self-insurance came from the Embassy of Heaven?
Oh, okay. Well, that's very important to hear that. That's
It's not, might not be that important, being that that is not a government agency. So if you're reading something that says it's supposed to be a government agency, it's not going to fulfill the elements, since that is not a government agency. So not saying not to get it or do it, but if the rules, and this is why it's important to talk about on Newbie Tuesday, because we're talking about elements of things. So if the element of self-insurance requires that the certificate come from a government agency, then it would fail the element if the issuing entity is Embassy of Heaven.
right. I get it. So I was just trying to figure that out. So you're saying that if you're doing the Embassy of Heaven self-insurance, you basically got to bring heaven with you everywhere you go, and don't even go into their
That's
jurisdiction.
what I already do now. I mean, so
Yeah. Me too. It's just a question of if I can join the other person with me. I'll give a big hug right away. I'm so sorry. I love you. God loves you. Let's work this out.
Yeah,
I
that sounds like
mean,
that's in the
that's
spirit
what we
of like
did.
a notice of intent. If you need to get it to people, if in the future, like hey, there's this notice of intent or whatever to make people whole if or when you
Yes.
damage someone's property. Other than that, to get a statutorily scribed or suggested insurance, I don't think that's necessary, especially if you're doing a secondhand buy, honestly. And all I think you need is that notice of intent and a bill of sale. That's it. But that's my opinion. I'm open for correction.
Yeah, that's a great idea.
And just kind of have it in your glove compartment for just to give it to. Here's my notice of intent. I don't have insurance, but this is what I promised to you.
Yeah.
That's what you're saying. Okay, I like that
And
idea.
just as a side note, if I could, I don't know if it's California, but I know where I live, if you get into any kind of accident, a lot of times people will try to call the police, and they'll tell you, unless somebody's hurt or like is a big accident, you guys handle your shit. They won't even come out. So just thought I'd throw that out there.
No, it should be.
Good
That's
point.
New York doesn't do it that way.
I mean, a lot of places where I got into my accident, I was in Miami. And the second time it happened, I was not behind the wheel. My manslave was. The cops did show up, but they didn't ask us for any insurance because we were not at fault. It was a commercial vehicle that bruised off the side of our truck. So we did not have insurance. However, the policy officers never asked us for insurance either. They just wrote up the guy, the commercial driver, and that was the end of that. And so we were with them for maybe an hour or so, and then we made an insurance claim on the commercial vehicle guy's insurance, and they paid us out, and we replaced our stuff in our car, and that was the end. So even though policy officers did show up, it still didn't result automatically in a ticket.
Right. In New York, they are going to ask for both people because it's a no fault, and everybody has to be involved somehow. It seems, I don't know about with commercial vehicles, but with between two private people, that's how they
But that
work it.
seemed insane that a private seller is trying to require you insurance because, as you guys also know from my own firsthand experience, my sister was a dealer. And you guys were, a lot of you guys in this call were already part of our community when both of our sons got their cars. And I told you guys all about that, including the one that gave us back a check of what they charged us for the taxes. And neither of them required insurance. And these were local car dealerships, guys. So to hear that a private seller, I don't care where, is trying to require insurance. Because my sister called when we did it the first time. Yeah. And she was like, they let you leave without insurance? The dealership. The dealership let you leave without it? Yeah. They didn't. As soon as we got into that argument about the taxes, they didn't say shit about no insurance. They let my son ride off that lot, hanging out his sunroof. Okay.
Yeah.
So I recently purchased a vehicle and didn't have insurance for 2 months, and then ADOT, Department of Transportation, sent me a notice stating that they're going to suspend the registration unless the
Threatening me with a good time.
insurance.
What? Eldon, what are you gonna do with ADOT, man? You gonna make them stop? You gonna make them stop talking to you?
Well, I finally, by the way, speaking of ADOT, I initially filed the petition, or what am I trying to say? The suit, May 29th or 13th last year, and I had to keep on getting extensions of time because I'm dealing with these other situations. But finally, they said no more, and I officially filed my suit with ADOT about 2 weeks ago, and now, which I did in Yavapai County, and the state is, of course, requesting it or demanding it to be transferred down to Maricopa, which is fine, which will give me another 30, 45 days to get my ducks in a row for some other things for that. So, but yeah, you know me.
Yeah, just to tell you about that guy. Yeah, he was a neurotic man, and I ended up getting $100 off the price of the vehicle because conveyance because of it. I said, if you're going to be so nasty and neurotic, I'm taking off money from in the sale, and so he agreed.
Okay, well, that's dope. That's really, really good. Because ultimately we are always going to have to do our best to protect ourselves when doing the quote unquote consuming, right? And that's another thing I want to make sure that I make paramount here. because it seems like that's a reoccurring thing that's popping up, at least to my ears, as well as I know others. When these people are using your data elements to bring about adverse things as far as how you would like to have peace of mind, if it's adverse to your peace of mind, I think, you know, running away from your consumer protections is not wise. I would start wrapping my mind around more how to go toward it instead of away from it, because it's a two-way mirror, so to speak.
Maybe you're gonna have to have a class on the United States Department of Agriculture versus Kurtz again,
I
or at
know, right?
least not again, but going over that case.
Yeah, because that USDA
Come back on Friday, guys. We'll go over the case again.
yeah, it's important that USDA v. Kurtz is groundbreaking and unanimously decided. Some will call that landmark, I think. But I yield. I yield. All righty. No one else? You good? You done, Aza? I mean, pardon me, not done. Are you complete with what you were sharing?
Yes, I'm interested in hearing what you're going to share on Friday, but yes, I am complete. Thank you.
All right, indeed. And Ron is next. In gratitude, Aza.
Hey guys, let me see.
Peace.
Hey, hey, can you hit? Hold on, get back in the truck real quick. How y'all doing today?
All is well, and yourself?
Then my question. Oh, wonderful, magnificent, great, bro.
Indeed.
So my question is about. It's kind of similar to what the gentleman was asking, but we have a person that filed their taxes and then they got a letter back from the Internal Revenue saying, "Oh, we changed your taxes," and I was like, who gave them permission to do that? That was my question to them. And so I said, I'm not sure of all the elements that they need to prove, but if there was no error in your math, then why are they changing your documents? This is my question. So that I was wondering how to address that issue, but that was my thought process.
The boomers that when we were younger that were working the IRS are little to few now working the IRS. And now you have what they call artificial intelligence now um, doing the observations or analyses of what's being filed. On top of the fact that taking a lot of the boomers' place at IRS is Boomquisha, Pookie, and Ray Ray. No offense. So what you're absolutely sort of kind of up against, or a way to handle it, is to get familiar with the TBOR, which is the Taxpayer Bill of Rights, as well as the Taxpayer Advocate Service, so that you'll be able to articulate what it is that you're seeking to get as a favorable reply. Whatever you need to articulate so that you can be rendered a favorable reply, and then bring those things about. Instead of, because I know it's infuriating. It's definitely annoying. It's making this a nuisance on your post, so to speak. But for me, if it was me, I would be utilizing the TBOR to bring about what it is that's needed, as well as the Taxpayer Advocate Service, because that then will make them know that you're not just clenching your fingers into your palm and just wagging it about over your head with a pitchfork in the other hand. Does that make sense?
Mm-hmm.
It's an intelligent
That's
tone.
making sense.
Yeah. So you will be proceeding with an intelligent tone so that you'll be rendered a favorable reply. I yield, and I'm open for correction to anyone else that wants to share.
Yeah, that sounds good. It absolutely kind of sort of sounds good.
Okay, gotcha. What was it? What was it for, Anron? Was it the W-2 situation type? You was, box 1, box 2, box 4, and 6, that kind of energy, or something else?
Also,
Yeah.
on that same note
I
that
know
Hassan just
I
said,
did.
you can ask them how they got to their results.
Correct.
One more time. For some reason my phone is breaking. I'm on the road, but can you please repeat that question?
She said, articulate to them in an inquiry, right? Ask them, how did they get to their results? I 100, if not 1,000% agree with that. And I'm saying, to be able to get to that, use the TBOR to be able to articulate it, because you'll know that when you read the Taxpayer Bill of Rights, you see that you have a right to adequate information. And so then you can then ask,
Okay, so
how did they get to their determination? Go ahead, Ayel.
okay. Yeah, I think I had that happen to me. It's like you owe $20,000, and I mean, oh yeah, and they said they did my taxes, and I just asked that question. Well, who gave you authority to change anything? And I don't even remember sending anything saying I was participating in anything, and they just sent me a letter saying they would get back with me, and that was about 10, 15 years ago.
Wow. Okay.
Interesting.
Take care.
That's amazing.
Okay.
But yeah, I definitely, that's a good question that you asked about how they got to their numbers, but also what gave them, by what authority. Great question.
Yeah. And man. Okay. So I know y'all recorded this also, so hopefully I can get a clean copy so I can hear what's going on. I think I'm driving through,
It's coming.
but I
Repeat
appreciate you
after me,
guys. If I get
Anron.
clear,
Yeah.
if I get clear,
Repeat after me,
I'll
bro.
call back.
TBOR.
TBOR.
Correct. That's all you got to look up. That's your homework. TBOR. And that stands for Taxpayers Bill of Rights. TBOR.
Okay, got you. I'll do that right now.
D, gratitude. I think we have next, it's Tice. What's up, bro?
Hey, so I just wanted to kind of expand on that one man that was talking about his traffic case as far as wanting to prove everything, because I'm going through that right now. You know everything. And I'm going through a child support issue, and it's easily procedurally pierced. However, now that I went back and looked at the root of everything, and understanding that my ex-wife is not the true plaintiff, and they're looking to attach administratively, and I also got welcome the child support letter. Wanting to go out there and go to war and prove everything when that may or may not be necessary. But however, I do want to get that on the record that I'm aware of their cooperative agreement, administrative tiptoeing scheme they got going on. And that's it.
Go ahead, bro. I was just agreeing with you.
Yeah, no, that's really all I had to say is wanting to prove everything when you could kind of probably fight it off because there's procedural defects always.
Exactly.
Thank you. Appreciate you guys.
Yeah, gratitude, Tice. Gratitude for sharing that, guys. I want to,
joke about the
I want to just second or third that honestly, because like, guys, I get it. We most of us are of the generation of Murder She Wrote and Matlock and all those other types of courtroom lawyering things, night court, right? With Bull, right? You know what I'm saying? Like in Marsha Warfield, like we have had these things socially engineered into us, where we have this automatic response within inside ourselves that says, "Oh, we can't go up against this," or "We're going to have a hard time," or "They're the big thems and we're the little us's," and that is the farthest thing from the truth, right? First of all, that was Hollywood or some other studio where they did that filming of that portrayal. All right. What all we need to do is really just look at it like, okay, this is actually simple. I really need to just be familiar with the rules of procedure, the rules of evidence, and the local rules of that particular court. I need to absolutely be familiar with the docket and then pick apart if I'm on the side of fending things off, quote unquote, the alleged defendant, then all I need to do is just find where they have a procedural defect. In other words, they either skipped a step or they just did something that is not everything that needs to be complete. Some duck is not in the row or properly placed within the row, right? So I think if we allow ourselves to lean more towards that and wean off of the internet sensation of guru abuse syndrome, we'll do much better psychologically, even if we're not ready to put things in yet. At least that will get us more prepared. I'm open for correction before we get to Lisa.
100% agree on that.
Gratitude.
But to top it off, though, in my opinion, I think it would worthwhile to recognize at the same time that you're preserving the record,
Yeah.
and you will blows will be thrown at you, right? But it is also important to recognize again that you're actually in the process of seeking redress or using the court to clarify some issue, which you have a meaningful opportunity to be heard in a meaningful manner. But I yield.
Indeed, bro. I love our squad. All right, Lisa. What's goody in the hoodie? What's up, Lisa? How you doing? All is well?
You guys are all awesome. Thank you for everything you all do. Greetings, friends-in-law. I just want a confirmation. I'm pretty sure it's not necessary, but the motion to strike I put in the comments earlier. It's not a requirement to attend, right? Since it's Newbie Tuesday, I'm gonna ask it.
Who is asserting the motion to strike? And for what reason?
It's a motion to strike attorney's authority.
Oh, okay.
Yeah.
Here's my question to you, particularly in the jurisdiction near you, whatever state that is, right? Is that the way you go about noticing that you're going to put in that motion to challenge their authority or to have them prove? I'm sorry, not challenge. Let me correct myself. You're going to put in notice and a motion for them to prove their authority to try the case?
No, it's a motion to strike.
Mm-hmm.
The entry and filings of the prosecutor, the district attorney.
Okay.
So the hearing, I also requested a hearing, so the hearing is set for April 9th. And my question is one required to attend that hearing?
So when it comes to, okay, this is a part of what I and even Quang was saying earlier, just a couple of minutes ago. Don't be afraid to quote unquote go to court, guys. Right? If you decide that you don't want to go and you want to do everything to not go, then assert whatever documents you need to assert to not go. However, if you're putting in a motion, I would show up. I'm open for correction, though.
I just want to know if it's a requirement because it's not for me, it's for my nephew. He's still
Nothing
dealing.
is a requirement, but if you file a motion and you don't go, it is unlikely to be granted in your favor.
Oh gosh.
Correct. Not that it hasn't happened, that people haven't shown up and they put in motions and it got granted in their favor. It has happened. We got evidence of it. However, that's not what we're promoting. We're promoting if you're going to put in a motion and set the hearing, you want to be front and center. If it's scheduled for 8:30 p.m., 8:30 a.m., be there at 8:25 or 8:15.
Okay,
But
it's
No,
but
gonna
but
be
typically
on.
remember
it's virtually.
remember it's filed with a notice of motion and hearing also.
What was that trading?
I'm saying it will be filed with a notice of motion. Notice of motion for a hearing. Hassan just told you about the date. So I'm saying to file a motion, it requires that you file a notice of motion to secure a date on the court's calendar.
Yeah, I
Correct.
didn't file a
You're
notice.
bringing the other party notice of the motion, and at the same time, you're asking for a date on the court's calendar to have your motion heard.
Okay.
As well as you could also request that it be done without any oral argument, just decided from reading the document itself.
Yeah, I didn't do that, and it's already submitted, and the hearing is set up. So when one attends the court, I guess, what does one refer to the motion?
That's all you read. If you wrote the script, if that's the script you wrote,
Yes, you
that's
argue your
out.
motion.
Exactly.
Okay,
Well, you know the reason why the motion was filed, and that's the reason
right,
you're, yes.
right.
Go in and shake that spear. You know what I mean?
Yes, well, it's not me, it's my nephew, so he's not
Wow.
as learned. That's the problem. So I'm gonna have to get with him soon.
Yeah,
Okay.
he can. He
Part of the
can.
problem, the part of the problem is, again, I'm glad this is Newbie Tuesday.
Word.
He got a ticket from, and the state is the plaintiff. The challenge
Yes.
to the attorney authority is unlikely the best move.
Did
Okay.
Malika go out?
I'm just gonna encourage everybody to check out our Sue Now What criminal edition. It's not the same exact thing as the Sue Now What civil. If an attorney is hired by a corporation, Walmart, Bank of America, Citizens, whatever, it is required for them to be hired for litigation that there's a vote by the board of directors of that corporation pursuant to the Business and Commerce Code.
Word.
That is not the same requirement, the same reason to challenge the attorney's authority in a criminal proceeding. So, in my comprehension of what you said, and in my experience with helping people, the challenge to the attorney's authority being used the same way as in the civil stuff, if that's not proper procedure. If it's a criminal issue, you have to focus more on whatever the elements are of their allegations and whether they're deficiencies in the face of the document, whether they're not meeting or all of the elements of whatever they're alleging. So it could be the form of an abatement based on, again, the lack of whatever the elements are, lack of fulfillment of all the elements, or an expansion of the administration outside of the intent and boundaries. Those are the types of things that have to be challenged. So although we're focusing on whether it might behoove your nephew to attend or not, the procedure underlying is I don't think that motion is going to be granted because it's a criminal procedure and the state is the plaintiff. So you
I know
can't
that detail.
disqualify them on the same reasoning.
Well, the reason I did this motion was because, let me see, the other one I filed was mm, it was the challenge to the attorneys, the notice to the challenge to the attorney's authority and declaration of private capacity before the motion to strike, which is requesting the vote.
Those
or
are in essence the same thing, attempting to do the same thing. Those are essentially the same thing, because a motion to challenge the attorney's authority, the request for relief is to strike everything because they could not show their authority. So the attorney's motion to show authority and a motion to strike are two things using to accomplish the same object. And the only reason why they're talked about separately is that because in some states, they call it a motion to show authority or prove authority. And when it doesn't call it something that official, we interpose the motion to strike, or the word strike instead of authority, because it has the same object, which is striking the attorney's appearance and their filings. Does everybody understand?
Okay, and so by looking at, I've been listening to Pigpen a lot. So that's kind of where I thought I was going with this. But it sounds like that's probably not the route.
So this was a so-called traffic ticket issue.
It's yeah, DWI. We had our first
DWI is not the same as traffic per se, even though it was during something traffic. It's not the same thing.
Okay.
And even so, it's a public entity, the state itself, claiming to be the plaintiff. So to challenge the attorney's authority because they might not have been hired by the proper entity is typically not, it doesn't even make any sense to do it that way.
Should her energy be more directed to did the attorney general of the state assign them to
whatever element? If that's an element, that's a great question. If that is an element of the charge, then yes, you would talk about that. But it should still be focused on the elements of the charge.
Okay.
When it's a public plaintiff. Does everybody understand?
Word.
So like capacity.
If the capacity is one of the elements of the charge, then yes, then you would, it's whatever the elements of the charge are. Whether you have to be in a particular place, whether you have to be in a particular capacity, whether you have to have been doing a certain thing, that all speaks towards what the elements are required and what elements should be challenged.
Okay, so perhaps an abatement, notice of abatement would probably work best.
I think you have to find the elements of the charge first to find out what you'll be trying to abate.
Okay.
I would agree with that.
All right. Thank you, everyone.
You're welcome.
Yes, good questions. I'm glad you brought it up. Thank you.
All righty, Josette's next.
Hi, thank you for taking my call. Mine's kind of similar, but my tort is in the claim of commission's board or something like that. And so the claim's been submitted to them. It's been submitted to the attorney general. And I was wondering if I was if I would be able to use a notice to the attorney to show authority. Would that
Is the plaintiff a public entity?
Yes.
So then explain to the class. Explain
I'm
to
the
the
plaintiff.
class
Sorry.
why. Is the
I'm the
defendant,
plaintiff.
if the defendant a public entity?
Yes.
Okay, so explain to the class how that would be a proper challenge or why.
I didn't know. That's why I was asking.
Well, what are the elements for the attorney to show up on behalf of the state? Are you suggesting by your challenge that one or more of those elements are missing?
You
have to know what they are.
Right.
Because
well,
let's say, for example, as Hassan brought up a few minutes ago, that one of the elements of the charge that the attorney general brought it, or the attorney general signed off on it, or the attorney general hired that individual officer or agent for that individual case. Let's just say when you read the rules that that's the requirement, that's one of the elements, then of course that would be grounds upon which you can challenge that they're showing up if you suspect or have reasons to believe that they're missing this specific qualification for this case, then perhaps, but not just generally as what we do with the civil cases, because the reason for the challenge with the civil cases is what we have found is that they never have it. The attorneys that are showing up in criminal cases typically work for the states. Yes or no? They are getting paycheck. They're working for them. When attorneys are coming after us in civil cases for credit cards and stuff, they don't work for the company. Does everybody realize that? They don't work for American Express. They don't work for Discover. Does everybody realize that?
So, yes, they're a third party.
Right. And because they're third parties, they need special agency delegated to them from the board. That is the reason for the challenge. And the fact that we have discovered that for whatever reason, whatever glitch in the matrix, they never, ever have it. So for us, it is a strategy in civil cases to challenge the appearance of the attorney, to strike their appearance and their paperwork if the state doesn't have a specific show authority or attorney authority statute spelled out. So you have to have similar grounds. And again, like Hassan said, did they require the state attorney, attorney general, or whatever to explicitly assign them to this case, and you suspect they didn't? Because even if they go, oh, well, we didn't have this assignment, so perhaps they no lay prosecute, which is great because, they're lazy, they're unlikely to bring it back, but they can just get the authorization from the attorney general if that's one of the required elements, and just bring the case again, and then you're going to have to find something else to attack, which is why we suggest from the beginning, if it's a criminal case, see what the elements are and attack what may be missing. If they have footage of a camera, you can always say how obviously that camera is not a live witness. There's nobody to corroborate that story. I want to do a motion in limine or some other way to suppress that inadmissible evidence, since it would be hearsay if somebody can't come and corroborate it. So those are
this is a tort claim. So part of the tort claim was a citation. The other was a criminal prosecution, I guess you can call it, for having a suspended license. So I did a tort claim. Risk management said that they can't get it done in 90 days. So they sent it to the commission's board. So that's where it is now.
Good.
And so that's why I was wondering.
Again, the principle is the same. So you can answer the question over and over again, multiple cases, whether you're the plaintiff or the defendant. Are you challenging the authority of an attorney that allegedly works for the state? If the answer is yes, unless you can show that there's some deficiency in who was supposed to hire the attorney, which again would only be temporary relief. Okay, because they could always correct that by giving the assignment, and then you would still have to go and look at. And you said it's a tort claim, so for tort claims, all you're looking to prove is negligence. Why would you want to challenge the authority of the attorney? Don't you want the settlement?
I do. I just want to shut them down.
That's not the way. You don't.
Okay.
Why do you want to shut them down? You want them to pay you, right?
Oh yeah, yeah.
Okay, so why is shutting them down such a hard focus?
Well,
You're the
because
plaintiff, not a
right.
defendant. So why do you want to shut something down? Don't you want to open them up?
Yeah, you're
I'm gonna
right.
go fight it.
Yeah, that's true. Yes, that's what I want to do. Okay.
As the plaintiff, in my experience and opinion, it doesn't make any sense to challenge the authority of the attorney.
Okay.
You want a settlement. You want to get paid out. You want a resolution as the plaintiff. Do you not?
Oh, absolutely.
So I wouldn't use any delay tactics or anything to piss the other side off unnecessarily. I'm already suing your ass. I mean, come on.
All right. Thank you for talking me through that. I appreciate that.
You're welcome. Glad to help. Anybody got anything else they want to add?
Yo, Malika, I appreciate you saying that because that makes me realize and understand like there are different tactics to use in different situations. So if I want to tort claim for negligence, I'm not going to say, oh, well, he has no authority because I'm fighting against myself because, yeah, let him act outside his authority to get me paid from the
I'm
source.
not concerned about your authority if somebody's going to give me some money.
Right. But if I'm the defendant, oh, yeah, well, we're going to have to challenge that, buddy.
That's right. As a defendant, you challenge all of their elements.
Yeah, so it sounds like in most of the people that we heard today, no one was on offense. And so if there's any type of bar rat on the other end, whether it's the county district attorney or somebody that's hired by the board or someone, at the end of the day, the main thing is to poke holes in their claim by showing the procedural defect in the elements not being fulfilled. Is that the moral of the story, Malika?
That sounds very accurate to me, bro. Gratitude.
Indeed, gratitude. Any more questions, comments, and or suggestions? Tice, did you still just had your hand up, or you had something else to add, though, bro?
Oh, I didn't. I got plenty more to add, but I'll do it when I talk to you. But
by the way, love your
I didn't know I had my hand up.
Love your picture, Ty.
What's that?
Love your picture.
Oh,
Drop
thank
reports.
you.
Did y'all see
Oh
that?
yeah, no, and
yes, it's hilarious.
Yeah, I appreciate you guys. I got in my situation, I got everything. All their cooperative agreements. Well, most of it or anything like that. But like I said, I'll talk to you, I guess, on Thursday.
Yeah, indeed. Maybe possibly some other friends-in-law may be in there when you come on. You never know.
Oh, that's what I could add. I was ready to. I feel bad because I almost feel like Derek Gonzalez with a job because I've been going so crazy, all caffeinated, staying up till 2:30, 4 o'clock in the morning, going to work at 7, and for 9 days straight since this came, and I had an email almost
now
sent
you
to you
know
at
how
3
some
o'clock.
of us feel
I had an
over on
email.
this side. Right, Hassan?
And I tracked down everything all the way to the Social Security Act, the pervasive use of language. But the point I'm getting at is I had an email I almost sent to Hassan at 3 o'clock in the morning. Like, fuck it, here's $5,000, hire the whole squad. I'm
I'm
going
not
to war.
the only one.
I
I'm
was like,
not the only one thinking of Hassan at 3 o'clock in the morning.
Yeah.
Right? It happens. It happens.
And then I booked him and I was like still all fired up. I kept clicking on the wrong link, like starting appointments, canceling appointments. I was all fired up, but it comes in waves. Sometimes I'm like peaceful. I go through the codes, and you go like this, and you get disappointed. Then you get hot again. It's been there's been a lot of growth this last week. Having to be forced into this situation. So
The emotional and mental roller coaster is real.
Mm-hmm.
If I may ask, I'm not trying to shamelessly plug myself, but at the same time, why not? Is your state remedy assisting you?
For like motion practice, when I stay on track, right? Because like I said, I've been up and down, so it's I'll get deep into the documents and all that stuff. If I stick to purely motion practice, it's wonderful. Like when I first got it, I was like, oh, this is fucking great. Then I started messing around with the jurisprudence gym, and that's been good. And what I'm finding is, especially um, if I prompt that the right way, which I'm still learning to do, like I prompted it for specifically for negative avertments, and I found myself kind of being able to work better backwards. But yeah, no, it's for motion practice specifically. And then I was like, I was almost mad
I'm so
sometimes
glad
because
that someone is loving these specific negative avertments, especially
yeah,
because they work. Okay.
oh yeah. But again, but by me doing that is like, I'm going after, the state actors and things like that. Like I'm not even addressing the other issue. And it's like, is that necessary right now? But they also attach myself. So, we'll get it. We'll get a little strategy going. And, she wasn't shooting with me in the jurisprudence gym.
Indeed.
Love it, guys. Love it. Glad you guys are enjoying the jurisprudence gym. And for those who are actually new here, Linnea and others have been posting the Newbie Tuesday guide, the Newbie Tuesday study guide. So make sure you guys take a second, find it in the chat if it's not the last post, and download it. So that's one of the things I wanted to make sure I remind you guys. And also, for those who are going to be back with us on Tuesdays and Thursdays, Tuesday or Thursday, look forward to an exciting session this week. All right. So since no one else seems to have their hand up, we're going to end it here, guys. Peace. Gratitude to all my co-hosts and wonderful guests. Hopefully we see you guys again in the next couple of days. I will be on live in the evening times. I had to make an adjustment because in the mornings I'm outside, guys. I'm outside getting dirt under my nails. So until we meet again, peace, my people. Love and courage, especially.
Over